And you are now live on YouTube. Go ahead.
All right, good morning. So we'll welcome to the Board of Ethics meeting on March 24th. And we will, at this point, call the meeting to order. And we'll start the roll call with me, Ash Anand, the Board of Education member for the Warrensburg School District.
Robert Usey, Director, Warren County Probation.
Diana Palmer, Third Ward Councilperson for the City of Glens Falls.
Brian Plavsky, Warren County Public Defender's Office.
Thank you. The next,
And I do note for the record that Mr. Delory contacted the county and advised that a work issue arose at the last minute, which made it not possible for him to be here today, and he did send his regrets.
Okay.
So, but it does appear that there is a quorum of the Ethics Board to proceed forward with business as set forth on the agenda.
excellent. The next item on the agenda is reading and approval of the minutes from our last meeting held on February the 10th, 2022. Do we have anything specific on that?
Is there a motion to,
I'll make a motion to proceed with the approval of the minutes.
I'll second it.
all in favor?
All in favor?
Aye.
Aye. Now, did we decide to have vote from everyone? No.
No, just
Okay.
the two of you will be voting
All right, perfect.
today.
And then in that case, the approval from the minutes from February 10th passes unanimously. Next item on the agenda is unfinished business, if any, from the past, which we have no notes of, unless Larry, you have anything else to add.
I do not.
Okay. Next item on the agenda is new business. Is first of all the proposed time
Uh,
of the
that
20
was just, I wasn't sure how long that, I was trying to make an estimate of the time that new business would take for the agenda, and I think it'll take about an hour or so potentially to work through the proposed rules for the board. And if it's okay with the board, I can kind of move forward to lead that discussion.
please.
So we circulated to the, and posted with the agenda, a set of proposed standing rules for the board, as we've discussed in the past. And as indicated by the code that was passed, the Code of Ethics that was passed by the Board of Supervisors, there was very little in the way of process and procedure provided to the board and how to operate on a meeting to meeting and item by item basis. So at the direction of the board, my office prepared as a draft a rather extensive set of rules and procedures, which were circulated, and each member should have a copy of. And my suggestion to the board is that today we go through those in as much detail as the board would like, making any corrections, additions, subtractions. What I'll do is, as we go through it, I can do that in a red line version on the original, with the goal being that I would then circulate back a modified version for the board members to consider and potentially to vote on at the next ethics meeting that we convene. Kind of as a subpart to that, a good portion of the core duties and obligations that this board have are items or subject matters that, in my legal opinion, fall outside of the open meetings law, which is why the agenda does show some further board proceedings that will occur following the open meeting portion of today. It wasn't a concrete legal opinion, but more of a strong recommendation that, given this topic of what rules to use and follow, is not necessarily exempted from the open meetings law, that we do conduct the review, analysis, and commentary concerning proposed rules in an open meeting on the record for the public's benefit. So unless there's any questions on those initial thoughts and comments, we can kind of move through. And I can lead the discussion, or anyone else can lead the discussion. I'm not sure how much opportunity and time everybody had to go through them. And they are definitely draft in format. I guess I'll start with, were there any questions on the preamble? And the preamble is just laying out for the rules the basic building blocks of the authority for this board as provided by the code. So it does reference the most current version of the Code of Ethics, which was enacted in 2021 as local law number 6 of 2021. And based on that, it did provide for this board to be established, what the composition of the board would be, and also the scope of the authority that's delegated to this board by the Board of Supervisors, as well as the delegation of the authority to establish the rules and procedures and policies that the board believes is necessary to execute and discharge its duties. And with that said, that's why we have the proposed standing rules of procedures. The first section really focuses on conduct of meetings of the board. Per the code, this board is required to have at a minimum 2 meetings each calendar year. I set forth the proposed date for the first annual meeting between February 1st and February 15th of each year. And the reason for that recommendation is, and it is just a recommendation, that it's the first 14 days after the county obligation on employees and officers to file financial disclosure statements. So it would be the first available block of time first for the board and its members to do an initial review to determine compliance by officers, employees with the filing obligation. And secondly, it also meets a second obligation to conduct that initial review by February 15th of each year. That's set forth in the code. The second annual meeting date would be not later than April 1st. And my recollection from the code was that would provide the sufficient time required to do follow-up to ensure that any filers who did not file by January 31st had filed, so that the board could move forward to advise the Board of Supervisors should any mandatory filers have not filed by the end of March, or by whatever time period the board determines in March to be the deadline. And of course, that the board can meet at any such other or further dates as determined by the chairperson for the board, as properly noticed. I anticipate that the board, this meeting would constitute the second meeting of the board. It does fall within that time frame before April 1st. I anticipate this board will have some requirements to meet more than twice this year, in part to really get the rules of process moving forward and approved, to make recommendations to the Board of Supervisors for modifications to the code, but also to deal with some matters that arise and have arisen for board consideration. Any questions on any of that? If I'm going into too much detail, let me know and I can. If you guys had specific questions and you wanted to go to specific provisions, I'm not interested in talking through every provision that's in here. Just trying to do more of a highlight reel. of note that any action that's taken by the board does need to be by a majority vote. Under the current rules, a majority vote would be equal to a quorum. A quorum is 2 out of 3 members under the code as currently written. And once these rules are adopted in whatever form they're adopted, or even just the adoption of these rules, does have to occur by majority vote or by quorum. So I'm going to look at 1G, because in there it does lay out in more detail what I briefly stated regarding open meetings law, that the board has been given core responsibilities, powers and authority from the Board of Supervisors, which are limited to providing advice and recommendation to the board, meaning that the Board of Ethics does not have enforcement authority, only recommendation, the ability to make recommendations to potentially include recommendations on discipline or enforcement, but no ability to actually make a final determination on any matter that comes before the board. The board's role is an advice-giving role. Even though that advice does concern governmental matters, that advice that you're giving in and of itself does not result in or end up being a governmental function, which is the key piece of why the core areas of issuing advisory opinions to county officers and employees, being an advisory body concerning the financial disclosure statements by officers and employees, and also serving as an advisory body and as in a quasi-judicial manner regarding investigations of ethics complaints, all fall within that advisory role and would be areas that are outside the scope and coverage of the meetings law, which allows you not just to, which means you don't need to go into an executive session unless you choose to on those 3 areas. And the board does have the option to not conduct an open meeting, specifically when meeting to address one of those 3 core responsibilities of the board. And then I added in at the end of that first section regarding conduct of the board, that the board may use Robert's Rules of Order to conduct business upon any issue or matter that's not provided for by these standing rules. Did anyone have any questions on that first paragraph? I think it's kind of important because it does lay out functionally how the board will operate going forward.
I did have a question on G2. This is where it says that it would be 90 days before we brought this to the administrator or the other supervisors, right? If someone failed to file a disclosure. Is that correct? I'm reading that right?
In part, the code that was passed
Mhm,
set forth in the code
mhm.
that an affirmative obligation on the board to notify the county administrator and the members of the Board of Supervisors, meaning the entire Board of Supervisors, of any non-filed financial disclosures after 90 days. The code doesn't clearly state, in my opinion, when that 90-day period starts and ends. In an abundance of caution, I've assumed 90 days from January 1st. It could also be from February 1st. I thought it would be better for the board to have 90 days end sooner rather than later, which is why I keyed that second meeting to occur before April 1st, before the end of the first quarter, which would be that 90-day window. And as you'll see in these rules, there's a section to govern, there's a section of proposed rules for the board to consider for each of those 3 core areas of responsibility. And when we get down to that section on financial disclosure statements, there'll be more specific rules for the board's consideration regarding the notification process after 90 days. Now, the board has already made some determinations of how to reach out to employees and officers, but that was separate and apart and within the rulemaking function of this board and was not the 90-day notification that's contemplated by these rules. Specifically, for example, if an individual supervisor were to have contacted the county attorney's office or this board after January 31st, wanting to know the status of filings, it would be my legal opinion that under the code that was enacted, the board and my office doesn't have the authority to release that information until the 90 days is up and the release is done to the entire Board of Supervisors. And again, that might be one of those areas the board I know may have expressed some interest in making suggestions and modifications to the Board of Supervisors as we enter towards that process, hopefully around May or June of this year, if that's agreeable to the board. Does that help a little bit? The reason the 90 days is there is because that's the time frame the Board of Supervisors fixed.
Okay. It seems like a long time to potentially not know about a conflict if there was one. So that was my only concern, but
And it seems like a long period of time to not get disclosure in the first instance.
right, yeah.
But I think we did discuss this topic where there should be reporting available in non-compliance, which I think is the function. We can have the 90 days for the final review. I think you're right, where there has to be some kind of a compliance notification ahead of not just 90 days, but I don't know, maybe every 30 days to know where we stand and then have the final closure.
And if it's agreeable, when we get into that subsection or that separate section about financial disclosure, maybe we can have that conversation in light of some of the rules that are in there. And we could certainly tweak, modify. And I'm pausing while I think about whether the issue we'll have to have a discussion about is whether this board has the authority to supersede what the Board of Supervisors provided for with the 90-day notice. And I don't know the answer to that, meaning could you make a rule that requires the board to give notice earlier than 90 days? My initial gut is you cannot, because that's a limit. But we can talk about maybe some options in the rules to address the concern going forward.
Would an option be to make a recommendation to the full board that the 90 be reduced to whatever time frame, say 60?
The board of
100%.
supervisors.
The board of supervisors.
Yeah, 100%, or 45, or whatever, or February. Well, February 1st would be a little too aggressive because the county attorney's office just needs time to assemble. But certainly, I think those are the kind of recommendations I would hope the board would be open to receiving. The Board of Supervisors would be open to receiving from this board.
We also have two different variations for this. One was the completion, and the second was actual compliance of the correctness. And we just discussed this. Just because it was completed didn't mean it was completed correctly.
That's correct.
So where does that provision fit in terms of?
Okay. As far as tracking ARPA, I'm going to be attending. I'm going to be signing up.
Unmuted? Okay, great. Let's go into paragraph 2 on annual review of financial disclosure statements. And I think as the board works through these recommendations, that may assist us and may assist the board in either answering questions or wanting to modify these proposed rules, because these will be more specific. So I am going to go through these a little slowly, please stop me or ask whatever questions you may have. So 2A is that on or before February 14th of each calendar year, the board shall conduct that initial review of all financial disclosure statements filed by county officers and employees who are mandatory filers under the code. Now, the code does require other individuals who meet the requirements that are set forth in the code to also file. The issue or concern that I have is it's not necessarily possible for the board to know other discretionary filers who may feel the need to file who have not been listed on Schedule A. Because individual employees might, who are not listed on Schedule A, may deem themselves fitting in the category that needs to file, and we won't know that until they file. So I'm kind of out there a little bit on the cloud, maybe a little bit, not the computing cloud, but the thought cloud. And I think what we'll see with this year is there may be some individuals who filed who were not deemed mandatory filers, but believed that they fit the requirements for filing, so voluntarily filed anyway.
But do they fit under the governance of what we are trying to do?
Yeah, there was a standard set forth in the code of who has to file, number one, and then number two, the code provided a specific list of who was deemed to fit that. My only point is that there may be a handful of other individuals who self-reported and filed, even though they were not on Appendix A. However, for purposes of review and analysis, you can only review and determine who filed based on the known list of filers, which are the people under Schedule A.
And the reverse of that is that if there are people who should be reporting that aren't on Appendix A and did not file, and how do we make that determination?
That's a great question. And short of going through the
List of county employees and knowing who has what duties?
I think to a certain, there has to be a substantial amount of, let me rephrase that. Given that the Board of Supervisors is delegated to this Board of Ethics, the duties and responsibilities delineated by the code, I think it's fair to assume that the Board of Supervisors and the collective staff of the county, to include the county administrator, Ryan Moore, accurately identified those individuals that they had a core concern about in their positions. To the degree there may be a handful of others who self-reported, I think that if my office can segregate them out for the board, we will do that. And that might be a recommendation to just add them to a Schedule A for a modified policy for future filing purposes. But this section of 2 is limited strictly to those people who are on Appendix A. My gentle, simple point was merely we can't determine compliance from people we don't know about. Meaning the board can't necessarily go through the entire list of employees and job duties descriptions to ensure on an annual basis that everybody who filed did file. We're limited to Appendix A.
When you talk about self-filers, are there people in the county who just file on their own?
I don't want to say that for certain.
On the department head believing that these individuals should file.
There is a portion of the code that does require individuals who fit under the requirements to file and not listed under Schedule A to self-report. I believe there is maybe 1 or 2 who did, but I don't want to misspeak on that. And it could have been a department head, or it could have been the self-motivated that they knew they were not on Schedule A, but their duties and responsibilities clearly were within the scope of reporting.
In that case, should we just rephrase these to add the self-filers from a compliance standpoint, even though we wouldn't know the exact list?
Yeah, I think that may fall more under that annual review of the policy rather than how we're going to review financial disclosure as it comes in.
Meaning that this board would make recommendations to the Board of Supervisors as to who should be added to Appendix A?
Yes. You certainly have the ability to do that. So under D, the recommendation, and one thing you'll see in here are references to form documents. And they're not form documents that my office has drafted yet. They're recommendations that they would be form documents that this board would use and approve. And if it's agreeable as we go through them over the next month, my office will prepare those proposed documents to be attached to this. So we're not recreating notification documents, and things can be more standardized and formatted going forward for this board and just easier to use if and when these documents need to be used. So for 2D, after that initial annual meeting, there would be a more standard form that would be a failure to file notification that the board would issue in writing. It would go to any mandatory filer who failed to file for the current calendar year. It would basically say those three core things: that the individual was required to file under the code for the current year, that they failed to file, and that the recommendation that my office put in was that within 14 calendar days after issuing the failure to file notification, there would be a mandatory personal appearance of the filer and the filer's department head at the second annual board meeting if they fail to file within 14 days of receiving that notification.
Now, this is 14 days after the 90-day period as it stands.
No. So this section D is that the board would meet. The board would be able to determine who did not file. And I think the language in 3 needs to be changed a little bit because it's not as clear as I would like it to be. But that this board would then direct a notification to go out to the non-filers that 1, they're a required filer, 2, they didn't file for the current year, and 3, that if they fail to file within 14 days after getting this notice, then that there's going to be a request or a mandatory request for them to appear in front of the board with their department head as to the reason for violating the code. That's merely a recommendation. Please feel free to hate it, to love it, to modify it.
I think this again goes back to the earlier point from Diana about clarity in terms of timelines. That's my only concern with this, as to clarification on the time frame. If we are going to meet 30 days after the initial filings are due, do we then notify after the second meeting, or do we? When do we know these are the ones that are non-compliant completely?
Okay, so what we did this year, which seemed to work, and I'll let everybody know now that there has been 100% compliance according to the schedule and the records that my office has received. So everybody who is a mandatory filer has filed for 2022, which is wonderful news. So that initial deadline to file is January 31st. Under the code, there's a requirement for this board to do an initial review and notification and follow-up with non-filers by February 15th. So these rules are proposing that this committee, this board meets between February 1st and February, I think I said 14th, in order to do that first task, to determine who hasn't filed. And of course, to conduct any other business that you want to conduct, but the core would be to determine who has filed and who has not filed. And then the proposal is that from that meeting, there would be a notification that would go out that was a failure to file. And that notification per 2D would basically say that the individual receiving the notice is a mandatory filer. They didn't file for the current year. And that they'd have 14 days after the notification's issued to file. And if they fail to file, then this board would require them to personally appear with their department head to address the non-filing. I created all of that out of thin air because there was no guidance provided by the code. And it is nothing more than a discussion point for this board to determine if that's the type of policy they'd like to use, if it's too much, if it's not enough. But the plan would be they file by January 31st, the board convenes, determines who didn't, they send out a notice, and then the follow-up is you give them time to file, and if they don't, what happens next?
So this puts us in roughly about 60 days timeframe.
Well, that would put you out about 60 days from January 1st.
Correct.
And at 60 days, then you would be in a position to move forward with that second annual meeting to determine full compliance, to review and make sure not just that everybody filed, but also to make sure that it was a substantial filing or substantial compliance, meaning that the actual disclosure form was properly completed and fully completed.
So would it make sense then that after that 14-day period, if they've complied, that's fine, that's good. If they haven't, so that would be under 90 days?
You're still under 90 days,
So,
but what that is recommending is that when you have that second meeting,
mhm.
they would actually be getting a notice to appear in front of the board to address their non-filing.
Mhm,
And that would still arguably be before the 90-day period.
mhm,
So we're
Without-
creating a series of remedies before we get to the 90 days.
mhm,
That way, when we get to the 90 days, hopefully we have full compliance and we can tell the board we have full compliance.
mhm.
That would be the concept to, for someone who doesn't file in the first 30-day period, who doesn't file more or less in the 2 weeks from February 1st to February 15th, and then who doesn't file for another 2 weeks after receiving a personal invitation to do so. Again, I'm hard pressed that anyone who's a county employee or officer would ever be in that position to have to appear before the board. But that would be the recommendation to kind of, carrot and stick it to, entice compliance, but also enforce for somebody for whatever the reason chose not to take full opportunity of the multiple opportunities to comply. And of course, that individual could file then before their personal appearance as well.
And they give ample time to file, and if you have an issue to, about your issue.
Yeah.
However you think we should do that.
Yeah, I throw it out. I mean, I know each of you have filled out the form.
It's not a heavy lift.
It's not a heavy lift. Some portions of the form might take a little time to understand, but that might be the more time-consuming portion of the current form, is just understanding what the information is, not necessarily reporting what information has to be.
And the current form is streamlined from previous iterations. So I think that, obviously that makes it much easier to comply with more streamlined form.
So let me keep going on, and then we can loop back and address the whole area of paragraph or section 2 as a whole. Under E, the board may grant individual time extensions to mandatory filers for good cause upon the request of an individual filer or the request of the filer's department head. So people may be on leave of absence or medical leave, or for other reasons unable to comply with the code timelines and then the procedural rules. So that will always provide the board the flexibility to address individual situations as they arise year to year. F kind of goes to what the chairman addressed, that the board shall review each financial disclosure statement filed to determine if the document is spatially sufficient. While it's not the duty or obligation of the board to evaluate the veracity, the truthfulness of information disclosed on an individual return, the board may decide in their sole discretion by majority vote to take all reasonable actions to verify the truthfulness, completeness, or accuracy of any information disclosed upon a financial disclosure statement, to include the lack of information provided upon a individual disclosure. And then what I'm offering to the board to consider as a definition of facially sufficient, meaning a document that you receive and review that meets the minimum requirements, would be, would a reasonable person reviewing that same financial disclosure statement have a concern that the answers provided are not responsive to the questions stated? And there's three parts to this. So not necessarily you with your background, experience, and intelligence, but with the reasonable person, with the average person who's reviewing the statement, have a concern with the answers that are provided and believe that they're not responsive to the question asked. Would a reasonable person reviewing the information disclosed have a concern as to the truthfulness, the veracity, or the accuracy of the answers provided based on common sense or an inherent conflict in the answers provided by the individual filer? And I think what that's looking for is there just a red flag that pops up in a person's mind? Not that you're doing like a forensic accounting on the document, but just on its face, when you look at it, you say, whoa, that something in there doesn't feel right or seem right to me. And then the third part would be, with the reasonable person reviewing the document have a concern that the document as a whole is not complete, or that any individual answer is not complete. And then G, that the board can take appropriate action on each disclosure statement which is deemed facially insufficient by a majority vote, to include but not limited to returning it to the filer with a demand for a more complete response, requesting a new disclosure. Oh, let me correct that typo. So sub 2 says requesting the filer to submit a new financial disclosure statement, and it should be a new paragraph that says, number 3, directing the filer to submit supporting documentation to address the stated concern of the board, and or new paragraph 4, which was old paragraph 3, requesting the personal appearance of the filer before the board to address the board member questions. I'm going to take out member to address board questions concerning the information contained upon the filed financial disclosure statement. So that's a lot of, in my mind, that's a lot of substance right there. And I wanted to take a moment to see if there's any thoughts, concerns, questions, recommendations, modifications that the board would like concerning paragraph F. And as I said, paragraph F is really designed to give each member framework for what they're going to do with these, I forgot the total number, but 100 plus statements on an annual basis.
There are various points of information which are requested on the forms. And just to be, sure about the completeness of it, should we have certain parameters that are mandatory requirements to be filled, which will make the process easier? For an instance, are you in compliance? Yes or no? I mean, it has to be answered. You can't leave that and skip and go somewhere else. Would that make the process easier for that compliance check for the forms? I know some people voluntarily provide a lot more information than necessary, and some are not providing enough. And just to make the process a little bit more streamlined, I thought the optional versus mandatory questions should help that process.
I'm not 100% clear. Can you give me an example maybe? That might help me understand. Also, part of what we're going to do later is go through all of the filed financial disclosure statements, which might help, since you kind of get a sense. I mean, you're going to be provided them to do that review after we finish the open meeting portion of today's proceeding. And maybe that will, the actual practice of going through what's been filed might help clarify what's in these rules, which will then help the board determine on final rules going forward, if that makes sense.
Yes.
So paragraph H is that the board will use the address listed by the filer on the disclosure statement as a mailing address for all written notifications to the filer. The board shall notify the county administrator and the board of supervisors in writing whether all required filers under the code filed a financial disclosure statement for the current calendar year. We'll disclose the names and employment positions of every county officer or employee who's a mandatory filer that didn't file. And I put that prior to the board's second annual meeting. I don't know why I did that. I think it should be after the board's second annual meeting. Because the written notice under the current code isn't until after April 1st at the earliest. So I think what that should say, and I think it's a typo on my part, is that the board will notify the county administrator. This is going back up to that one paragraph that member Palmer noted on the 90 days. This is the this is the portion of the procedure to notify the board. It should be after 90 days. So therefore, you wouldn't notify the county administrator and members of the board of supervisors until after the board's second annual meeting.
Talking about paragraph J.
Paragraph, I think it's paragraph I I'm looking at. And then the written notice shall be issued by the board on or after April 1st of each calendar year. So there's with that 90 days under the code, there's a built-in issue and problem of a disconnect, right? Because there's going to be the second meeting date that the board's going to have to determine, it's kind of your final meeting for compliance. And the way the structure and flow here again, and I apologize if I'm kicking the horse too many times. Everybody files by January 31st. The board does an initial meeting in that first 14-day period of February. Flowing from that, notifications go out to those people who didn't file. They get 14 more days. If after the 14 days they don't file, they get invited to appear before the board for that second meeting, with the goal being that you get 100% compliance by your second meeting. And if you don't have 100% compliance by your second meeting, then that requirement to notify the board on or after April 1st, which is 90 days. So that's kind of what the concept is there. And again, J is just the recommendation that by May 1st, the board determined any of the disclosures to be facially insufficient and that there was a failure to cure that deficiency, that the Board of Supervisors would be notified on or after May 1st, which is just giving everybody an additional 30 days after April 1st. Not that your timeline wouldn't be quicker, but it gives the board some time so this doesn't drag on too much farther into the year. And really what that's doing is just trying to account for all the possibilities and contingencies that might arise. My hope is that none of those issues arise, but if they do, there's a process and procedure for the board to consider and then to use going forward to address them. I'll give everybody a moment. Let me know if you want to move on or if there's any questions on section 2 of the proposed rules.
You caught what I had on too, that this piece right here needed to come out because it's conflicted with that one. Prior to
Yeah,
the-
yeah.
You caught that, yeah. And I think this is well done in terms of being able to be ready by the 90 days to give the board and the county administrator a full accounting of where the problems are, because it's late and incomplete submissions.
Mhm.
I think this is a good process.
Yeah, I think it looks good. I initially thought that maybe you could move the 90 days up, but maybe you can't, because you're 60 days by the time, you're 30, you're past 30 by the time you meet in February. You got 2 weeks to have people who haven't filed, so that gets you 60. You got to meet again, so, you know, so that.
And the meetings aren't, the notifications to the individuals who didn't file aren't going to go out the same day.
Correct.
So that 14 days, if the committee meets like around Valentine's Day, like, you know, depending on everyone's schedule, it would take a few days for the county attorney's office to prep those and then for the board to, what it means for the board to issue them, because my office will aid and assist and support, but it's the board that's actually sending them. So we'll lick the stamps, or we'll attach the stamps and lick the envelopes, but you guys are the ones sending it out officially.
Yeah, it's more acceptable to me with the staggered process that you put in there. Initially, I was reading it as 90 days until they had to be accountable, other than a reminder. But it seems fine
Yeah,
at this
there's
point.
a
Yeah.
process.
And I think the best way to really frame it is kind of where we started, which is the Board of Ethics in all of your delegated responsibilities is acting in an advisory capacity only, the Board of Supervisors. So even though we're doing those staggered approaches, it's all advisory. And at the end of the process, it'll be up to the Board of Supervisors, the county administrator, the department head, and the chain of command for any individual employee on what actions, if any, to take. So, okay, if everyone's okay for now,
Yeah, I think we can proceed.
I will move over to paragraph 3. My computer locked up for a moment. All right, I'm going to go with a paper copy because my computer's connection's having a little bit of an issue. So the next section is the ethics advisory opinions. All right, good. So one of the, as it's front, one of the core areas, one of the second core areas is issuing advisory opinions. There is not much meat on the bones of the code regarding what that entails or means. Hopefully this section will assist for this board to have a conversation of what it views that to mean for purposes of process and procedure. So clearly what the code does provide is that a Warren County officer or an employee, and it does limit the categories to officers and employees, may submit a written request for an advisory opinion from the board concerning proposed future conduct or action by a public servant, and for interpretation of the code and Article 18 of General Municipal Law. And the board will treat that request as an advisory opinion as confidential. The requesting party understands that a written request may be subject to disclosure under the Freedom of Information Act. So any request that were to come in would have to be in writing, signed by the requester, and either mailed or delivered to the Board of Ethics, care of the county attorney's office. Upon receiving a request for an advisory opinion, the chairperson will acknowledge receipt. And at that point, the board members would investigate, conduct fact-finding, any background research, to include legal research, review county policies and procedures, and then confer with the board's counsel. And by a majority vote, the board may choose to delegate such investigation to the board's counsel. The board will determine whether or not to issue an advisory opinion. So the first question is always, is this something that we can act on? And then the next question is, it's something we should act on. So the first is if the request is not within the jurisdiction of the board, meaning within the areas that this board is empowered and delegated authority to act in, then the chairperson will issue a letter explaining that the board is not going to take any action because it's outside the jurisdiction. And then subparagraph 2, if it's within the jurisdiction of the board and the board does have sufficient information, then the board can determine whether or not it will issue an advisory opinion on the matter. Specifically, the purpose there is that just because there's been a request doesn't necessarily mean it's something, it's not mandatory for the board to take action, and it's at your discretion whether or not it's a topic significant enough that it requires an advisory opinion. And the factors that we're recommending the board consider on whether or not to issue an advisory opinion are 4. None of the factors are required. They're all guidelines. Meaning 1, would the opinion assist the requester and guide future conduct? 2, has the board previously issued opinion on this same matter, or one that's substantially similar? But the concept being there is if it's a topic that's already been addressed, the board could modify and release that prior advisory opinion to the requester. Is the matter currently being investigated by law enforcement? And is there a conflict of interest by the board that requires recusal? After weighing those 4 factors, if the board decides to issue an opinion, the requested opinion would be issued within 90 days after the first board meeting held after receipt of the request. So the process for receiving, reviewing, investigating, and formulating an opinion is not necessarily something that's designed to be quick, in part because the opinion that the board issues is going to be long-standing. So 90 days is a outer limit for the time frame to respond to that request, and it would be 90 days from the first full board meeting to consider that advisory opinion and walk through those factors to determine whether it's 1, within the jurisdiction, and 2, a matter that the board feels compelled to respond to. Of note, again, because the board is advisory, I think it's important to outline in the rules that a county officer or employee whose action or conduct is the subject of an advisory opinion shall not be subject to discipline or sanctions for acting for failing to act due to reasonable reliance on the opinion, meaning someone who takes the time, effort to seek the opinion of the board. Should have some sense of security that following that opinion will not result in discipline or sanctions. And now that I'm looking at that provision, I realize that that is outside of the scope of this board, meaning the board can't insulate somebody because you don't have that authority from the Board of Supervisors to insulate somebody. So I think if the board would like, we could modify H that a county officer or employee whose action or conduct occurs after the issuance of an advisory opinion. I kind of want to say that the board would recommend no discipline or action for an individual who follows the advisory opinion of the board. If anyone has a quick solution on language, I look to our resident public defender's office appointee. If not, I can try to work on that. But the concept would be, because you can't immunize or prevent discipline or sanctions, but you could make a recommendation that someone who follows the board's advice not be subject to discipline or sanctions. Kind of a safe harbor, you would call it, or safe haven, that they take the time to seek the opinion, they follow the opinion, there shouldn't be any discipline or sanctions for following it. And then this is more prospective, that advisory opinions issued by the board may be subject to the Freedom of Information Law. I think that that's truly a case-by-case determination that would be made by the FOIL officer for the county. I suspect that there's some very strong reasons under public officers law why those advisory opinions may not be releasable. Of course, there would also be under J, a question to the board on whether any advisory opinion would be held as confidential or released more broadly to the county. And I guess what I'm going at there is there may be situations where there's a request for an opinion that's very specific and limited to a certain circumstance involving an individual employee. And in those very specific circumstances, the request and the opinion that's provided, the board may want to deem that to be confidential. Whereas there could be a request for an opinion that would have a much broader effect on a large number of employees. And the board may, in its sole discretion under 3J, release that advisory opinion to the public, thereby clearly making it subject to FOIL, because it would be a document that would be releasable to county employees at large for their educational purposes. So advisory opinions.
Maybe we can add the county attorney's discretion to assess that case by case for 3J.
I would not recommend that because it's within the board's authority to make that determination, not the county attorney's. The county attorney or your legal advisor, your legal counsel will make recommendations to the board, but at the end of the day, it's only the Board of Ethics that makes any determinations and decisions. And again, when I say determinations and decisions, what I'm really saying is advisory opinions, advisory findings, and and the like. So I don't know if there's any questions, thoughts, concerns, complaints about section 3, which is on issuing advisory opinions, particularly on that time period of 90 days. Like I said, I think it's important to have a not longer than time in there, that it's long enough to account for whatever comes in. Because in my mind, I can imagine a request come in on a matter that's substantially weighty and difficult, and the board might need to meet a number of times to come to a consensus on what that opinion would be. Others could be pretty straightforward and quick, but I recommend 90 days just because this is not a standing board with regular set monthly meetings. It provides the ability to meet more than once, well, at least twice, because you would do an initial meeting on a request, and then at least a final meeting to approve the response. 90 days just kind of feels like a fair, not later than time to do the steps that would be required.
I agree.
Seeing nothing, no other questions, I will move on to section 4, ethics complaint procedure. So in this section, which is, I believe, the longest of the sections and most details of the sections, I've again tried to lay out almost a step-by-step process for this board to follow as a recommendation. A core legal issue for this board when it receives a complaint is what we call due process. Due process is a constitutional requirement. It's a constitutional requirement under the federal Constitution and the New York State Constitution. And it's broken down in its most general construction as a two-part requirement. The first part is notice and notification. And the second part is opportunity to be heard. And what that basically means is, even though this is an advisory board, my strong recommendation is that the board operate with the concept and constitutional requirements of due process in mind, meaning that individuals receive notice of a complaint or allegations and an opportunity to be heard. That can be as minimal or expansive as the board feels is appropriate. I think these rules fall more on the side, if that's a spectrum, meaning there's like a minimum amount of opportunity to be heard, and there's something that would be considered a maximum amount. I think what's proposed here is more on the side of maximum, but closer toward the middle, meaning where the recommendation is that there be some very clear requirements for a board to move forward on reviewing a complaint, but that we don't take it to the level that you might see in a criminal trial or a civil trial, and that would be kind of the maximum standard for opportunity to be heard. And we don't do a minimum where somebody may just have the ability to submit a written statement and then you make a decision off of that. if that makes sense as far as that concept of due process with notice and then opportunity to be heard. So 4A, that the board is authorized to accept for consideration sworn complaints. I think I have a typo there. The board is authorized to accept for consideration sworn complaints bearing, it says being, it should be bearing the original signature. And it should also say of the complainant, meaning the person who's submitting the complaint, that are in written form. An ethics complaint must be in the form of a sworn affidavit and state that the statements made herein are true and accurate and are sworn to by the deponent and under the pains and penalties of perjury. Attachment A will be a default complaint form that individuals can then use if they want to ensure compliance with this requirement. It also means that the board must receive an original document with an original sworn signature in order to be considered a sworn complaint for further action. B, all sworn complaints will be sent by mail or delivered to the Board of Ethics, care of the Warren County Attorney's Office. And I'm just adding Warren County Attorney's Office, so it doesn't say Warren County Attorney. C, it's kind of I'm going to call it bifurcated. I'm going to call it a two-step process. The first step is really when one of these complaints come in, since they're coming in the care of the county attorney's office, we want to be able to provide an initial copy or notice to the chairman or chairperson for a preliminary review. And basically to ensure that there's a determination that it does constitute a sworn complaint as required by the rules. And that if it is a sworn complaint, it's then going to get a complaint number. And the complaint numbers will have the year that it's received and then be sequentially numbered 1, 2, 3, 4, however many come in during that calendar year. And then all future correspondence will refer back to the complaint number for that complaint. The chairman will provide, I'm going to change that to chairperson so it's gender neutral. The chairperson will provide the complainant with just an acknowledgement that the board received and accepted the complaint. And if it's not compliant with the standing rules and requirements, then the document will get rejected. And the complainant will be notified.
Will they be notified how to properly submit their complaint?
Or at the very least, why theirs was deficient.
I think it's fairly, what my recommendation would be is that we would have something that is a form letter. And as part of that form letter, we could always include a copy of the standing rules, which I hope would then also have an attachment of what the form complaint is, the recommended form for the complaint is, so that they can. Part of this, part of the recommendation in here, as you'll see, is that nobody's in the position of providing advice, particularly your legal counsel or members of my office. But that would also extend to individual board members as well when we get there. So I did make a modification that you'll see in the as a red line change when I send it out. that they'll be notified in writing with the understanding that the chairperson will want that form letter to contain a copy of the rules and the proposed form for it. D, the board shall not consider, review, or respond to any email, text message, or other form of electronic communication from any source which claims to be an ethics complaint, and shall not reply or respond to submissions which fail to comply with these standing rules. Are there any questions on that? Because that's a big statement. If the board is going to require a complaint that's sworn to with the original signed, which also states in there that back up, which that statements herein are true and accurate and sworn to by the deponent under the pains and penalties of perjury, that quote unquote submissions by email or text message, which are not even attempting to comply with the rules, will not be responded to. Any questions on that before I move to E? Seeing none. E, a sworn complaint filed with the board must state the following to the extent the information is available. And again, this would also be on that form complaint. The name of the person or persons who are the subject of the complaint, the department, position, and duties and responsibilities, the date, time, and location of the alleged violation, a detailed description of the facts of the alleged ethics violation, and which facts are personally known to the individual who's making the complaint or were discovered by you from another person or source. I'm going to modify you to say the complainant. And if it's agreeable with the board, or I would on the form probably use the word you, so it's a little clearer to understand for the person who would be filling out that complaint form. So personally known to the complainant or were discovered by the complainant from another person or source. If the facts were discovered by you from another source or person, state each and every source and person. The complainant's affiliation or association with the person or persons who are the subject of the complaint. The complainant's name and contact information to include the home address, phone number, and email if known, which is stated above if known. Supporting information or documents in the possession of complainant, which may be reviewed by the board or used by the board when making its determination. So that would be the format for that form of I don't want to call it minimum because not everybody may know that information, but certainly that would be the core information that the board, I foresee the board wanting to know at a minimum to make that initial, what will be the initial determination of whether there's something that should be done or not. Is there, as we go, let's go through the rest, and then I'd like to loop back up to those particular sections and re-review them with you to see if there's anything else that might need to be added. So F is no member of the board or the county attorney's office shall provide any assistance or advice to a complainant in preparing a sworn complaint for submission to the board. G, the board, within 60 days of receiving a sworn complaint, shall one, make an initial determination by majority vote whether the complaint is credible and actionable. The complaint will be deemed credible and actionable. And those are kind of key words that we're going to use going forward unless the board has a different phrase or standard they'd like to employ. The complaint will be deemed credible and actionable when the complaint as presented sets forth reasonable cause to believe that a Warren County officer or employee violated a specific provision of the code or Article 18 of the general municipal law. Now, reasonable cause is a legal standard, and it is a legal phrase. And it'll be defined as we move down through these standing rules, how the board would determine whether there's reasonable cause. And then G2 is that the board would dismiss any complaint that it deemed not credible and actionable and notify the complaint in writing of the board's determination that the board is basically not taking any further action on the complaint.
And that is being done by your office.
Well, my office is more than happy to prepare documents for the board at the board's direction, but it's the board that would be issuing that determination. And I'm going to make a note because that does raise a question in my mind that we'll loop back to specifically on who's signing. Now, before I go on, what I'm hoping the board will see is a kind of a tiered approach. I'm going to call it a tiered approach with an opt-out or dismissal at each step. So phase one, which is really what this is the complaint comes in. There's this initial determination of, hey, is this even a sworn complaint under our rules and under the code? If not, that doesn't go into the substance. It doesn't go into the details. It's looking at the face of it and the board delegating to the chairperson the ability to reject it because it doesn't even meet the facial requirements for a complaint. So that's kind of the first off-ramp where a complaint is, where a potential complaint is not even a complaint. The next one is going to be this initial complaint review procedure and investigation, which is kind of like a main phase one. So you do have a sworn complaint. It's facially meets the requirements. What do we do with it now? And the goal is for the board to determine whether it's credible, number one, and actionable, meaning is there something that the board by majority vote believes they can and should address from this complaint. If there is, then you go through this process. If there isn't, there's another dismissal requirement that would kick in at that point. And then when you finish that initial review procedure and investigation, which we're about to go through, there's another tier that would be available to the board to do a further deeper look, if required, if this initial process of investigation doesn't resolve in the majority of the board members' minds what the answer is on the complaint. All right, so that's a little, again, I apologize if it's a little out there and theoretical, but I just wanted to help the board hopefully in seeing what the big picture construct here is. Not that every single document that comes in is going to get 100% of the board's attention, but as you move through the process, you'll determine how much more is required. So under paragraph H, complaint review procedure and investigation, within 5 business days after the board determines a complaint to be credible and actionable, the board will issue the notice of complaint to inform the respondents, and the respondents would be the individuals who are the subject of the complaint, in writing that an ethics complaint has been filed against him or her. All right, so that's that notice portion. So within 5 days of finding that the complaint, that there's something here the board is going to look into, letting the person who's the subject know about it. Number one, the notice of complaint will provide a general statement of facts upon which the board relied for its determination that the complaint was credible and actionable. The notice of complaint shall set forth the provisions of law allegedly violated. I'm going to change that to provisions of the code and or law allegedly violated. Number three, the board in their sole discretion, meaning the board decides and nobody else, shall determine by majority vote on a case-by-case basis, excuse me, whether to disclose a copy of the complaint with the notice of complaint. The board may consider, and then there's factors that the board can choose to decision and weigh however they deem appropriate. The privacy of the complainant, the sensitive nature of the information set forth in the complaint. And I'm just going to make some typo changes in there. Those commas should be semicolons. Then it would be the sensitive nature of the information set forth in the complaint. Semicolon. The need to protect complainant from retribution or other negative consequences to complainant in the workforce, semicolon. The relationship of complainant to respondent or respondents. The risks to, I'm going to add the investigation caused through release. I'm going to put in of the complaint. And the due process rights of the respondent to be fully informed of the pending allegations in order to answer and defend themselves from the allegations. Now, if I thought long and hard, there probably would have been some more topics on the side of the respondent to consider, but the core one is really that due process right, the right of notice and opportunity to respond to the complaint. And the concept here is to give the board as much discretion as is possible to look at this specific situation and determine what's the safest and best route for everybody. And as I sit here, another factor could be the I almost want to say the weight of the initial evidence or statement provided by the complainant. There may be occasions where it's that initial report is so, appears to be at first look so clear that there's maybe either little risk in providing it to a respondent, or maybe even the opposite, a greater risk of providing it to a respondent because the violation on its face appears so apparent prior to hearing from the respondent, meaning you're not making a final determination, but the weight of it seems so clear as compared to one that's very ambiguous or maybe not as clear, but you still want to take action on because there's a concern that's voiced in that complaint. Yet I could imagine a situation where the board may be very reluctant to release a complaint that might be borderline or not that clear because you also want to protect the rights of that employee or that respondent by restricting the information that's released as part of an investigation until there's an opportunity to more fully develop it. I think it's really hard because you have to gameplay all the possibilities. And until you're running through it on any individual case, it's impossible to know what you don't know. So even though there's a bunch of quote unquote factors for the board to consider that would weigh in favor of the complainant, my hope is that the board would understand that the goal here is not to, we're not adding up points. The purpose is merely to try to brainstorm and outline some of the key reasons why you would weigh whether in any individual case to give the respondent a copy of the complaint as compared to what's set forth above in paragraph 1, which is a general statement of the facts upon which the board relied to move forward with the complaint. I'll stop speaking now, so you all can have an opportunity.
So I have a question on the initial statement that within 5 business days after the board determines. Now, just clarity wise, complaint comes in today, we are not scheduled to meet for another month. So is it from the time we meet 5 days, no matter when the complaint actually comes in?
Correct.
Okay.
And really the concept would be, let me back up one more time and just double check something here. My hope would be that my office, and I don't want to necessarily put a time on it, but that within a few business days of receiving a complaint, if not the same day or the day after, which is really the standard, that we would be reaching out to the chairperson, so the chairperson's aware that this complaint came in, that initial review to make sure it's really a complaint is appropriate, and then the discussion would be when's the next meeting. If there's one already scheduled, great, and if not, we would need to then call a meeting. But this process and the timeline really kicks in 5 days. That kicks in when the board meets to first review that complaint.
I ask because some of the complaints could be sensitive or time sensitive in nature, so that clarifies that. On the overall process of responding or reaching out to the respondent, at what point in time is the Board of Supervisors or the County Administrator informed about these?
We're going to go through that.
Okay.
You'll see that as we move through, and it's designed to be later in the process
Okay.
to give the board the opportunity to review whether using this procedure you move to a place where you're actually going to make findings of fact and a recommendation to the Board of Supervisors and County Administrator regarding the situation. Yep. So, okay, so that's what happens, and that's the information that goes out to the respondent within 5 days of the board meeting. And then subparagraph 2 addresses what the respondent's obligations are. And the respondent has 21 days after service of the notice of complaint to submit a sworn affidavit in response to the allegations that are set forth by the complaint. I'm going to strike by the complaint, or set forth by the complaint. So it would read, the respondent shall have 21 days after service of the notice of complaint to submit a sworn affidavit in response to the allegations. And the reason being is it's not necessary that this board release the complaint. The respondent might just receive the notice of complaint. And then comma, along with all supporting documentation that the respondent may want to submit for the board to consider. The respondent shall answer the notice of complaint by sworn affidavit made under the pains and penalties of perjury. A copy of the proposed affidavit for use by the respondent will also be attached to these rules as attachment B. Service of the notice of complaint may occur by any one of the following: personal delivery to the respondent, at their place of employment. Delivery is an attachment to the respondent's county email address or regular mail to the respondent's home address. After determining a complaint is credible and actionable, the board may investigate further and gather additional information to assist the board to evaluate the allegation. I'm going to make it allegations. Or delegate authority to conduct further investigation to the county attorney's office. As a general principle, I suspect I'm regularly going to recommend you don't do that. But I added it there, depending on the circumstances and situation, as an option that the board can consider. So then there's subparts to this. One, the board may serve a written demand for further information or documentation from the person who filed the complaint or the respondent at any time during this investigative phase. And you may require the production of an affidavit verifying that the additional statement or documents are true and complete. So, right, this is serious now, right? We're at the phase now. You got the complaint, you've given the respondent the 21 days to respond, either during that time frame or after you receive the response from the respondent. The board can move forward and now is moving into that investigative phase of this process. You can serve a written demand for further information on any other county employee at any time during the investigative phase. And you may require the production of an affidavit verifying that the additional statement or documents or that the statement and or documents are true and complete. The board may request further information or documentation, and I use the word may here, from any third party who's not a county officer or employee at any time. And you can also ask that they sign an affidavit that it's true and complete, either the documents or the statement. However, any production by a third party who's not an officer or employee is always going to be voluntary. I left 4 there because I didn't know if there was anything else that the board wanted to address or discuss as far as process and procedure. You know, to be honest, the concept here is generally in the state of New York, an individual has 20 days to respond to a civil complaint that's filed in court. 21 days just sounded easier to track since it's 3 weeks. And then that process for documents is really the board's ability to reach out and either demand specific documents from the person who complained or the respondent, any other county employee, or permissively request that someone outside of the county provide documents that they may have. Hopefully that would cover all of the possible contingencies. If there's anything else anyone can think of, let me know. Otherwise, I'll remove that number 4 later on. So the next numbered paragraph, which is I, is really what do you do now after you've finished that initial complaint review and that collection of investigation. Well, first is dismissal of a complaint without issuing a notice of complaint. So this is kind of backing up to before you start the investigation, is there reasonable cause? So if the board finds there's no reasonable cause to believe there's been a violation, then the board's going to notify the subject of the complaint in writing that a complaint was received, that the board determined no reasonable cause to exist to proceed with the investigation, and that the complaint was dismissed. The board will notify the complainant of the determination within 30 days after the complaint is dismissed. And the board will make a separate determination whether to advise the person. Oh, this seems a little bit conflicting. The board will make a separate determination whether to advise the person named as the subject of the investigation. And there's a typo in there too. of the filed complaint and the dismissal of the complaint, as well as whether to provide a copy. All right. So I think what I was trying to do here, and I don't think I did it right, is the thought process was, in this process now, you get this complaint, it's facially valid, you bring it in, that initial meeting, you review it, and you guys find that it doesn't really, it's not credible and actionable, and more importantly, it doesn't say reasonable cause to believe that there was a violation. And the board determines that you're not going to go and issue a notice to the respondent and give 21 days, and you're not going to do further investigation. So this is that off-ramp. And the concept I was looking for here, which I didn't quite get, and I don't know what happened, but clearly the person who filed the complaint needs to know that the complaint, nothing further is going to happen with it. And what I was trying to create is the ability of the board to contain that complaint and just notify the complainant, or if it's a situation where you felt that the subject also needed to know and be advised that it was filed and dismissed, that you would then do that further step. And what I did is instead both between number 1 and number 3. So the goal was really to try to, like I said, give the board the discretion on a case-by-case basis of whether just to insulate it, close it down, notify the complainant, or also take that next step. So I don't know if there's any feelings, thoughts on, because I-1 says that you shall notify the subject of the complaint. And I think that was supposed to say the complainant, not the subject of the complaint. But I'm not going to make a change until you guys tell me you understand what I'm saying and that you're okay. Basically, I want this, my suggestion is, my desire was for this section to say the person who filed always has to know, and then the board will decide in this situation whether that's it and it goes away, or if you're then going to let the subject know, who at that point had not received the 5-day notice and may not even know a complaint was filed.
I think that would be recommended unless you guys think otherwise.
No, I think that's the appropriate.
Right.
Okay. And again, you guys aren't making a final decision, but this just helps me to give you a final set of rules to review next month for approval next month or at the next meeting.
So 1I should just remove notify, shall notify, and remove the portion that says the subject.
I'm going to say then the board shall notify the complainant.
Right.
Rather than the subject.
Right.
Shall notify the complainant, comma, in writing, comma, and then that next part will come out.
So I3 gives us the necessary discretion and removes the shall portion of sub 1.
Yes. I will, I ask for the board's apologies because I will self-confess that I was doing this close to midnight the night before I sent it out, or had it sent out to everybody to make sure there was a full set of rules. Initially, I had discussed doing these each in pieces, but once I started it, it was kind of working, so I just kept working through it. So I apologize that I was not as clear as I should have been in getting you guys a draft. So again, is you guys receive the complaint as a board, you look at it and you decide you're not going to issue the notice of complaint and you're going to dismiss it. Complainant is informed within 30 days and you guys decide whether to let the subject of the complaint know. The next section, J, is dismissal after you issue the notice of complaint and you conduct the investigation, if any. So after you receive and review respondent's affidavit in response to the notice of complaint, If the board determines at that point, now that you've heard both sides of the story, that now there is no reasonable cause to believe that there's been a violation of the code, the board shall notify the complainant and the respondent in writing that the board determined no reasonable cause exists to proceed with an investigation and that the complaint is dismissed. So that's the next off-ramp. That notice of disposition shall be issued within 30 days after that determination by the board. And then no further notification Okay, and I believe it should say that within 30 days, notice of disposition shall be issued within 30 days after a determination by the board. That the complaint will be dismissed, that the complaint is dismissed. And that no further notification. It's not right. All right. As I wrote, it was correct. So, and no further notification of the complaint or allegations in the complaint shall be provided to any person. So again, all that's happened at this point is you got the complaint, you got the response from the subject or the respondent, and now that you've seen both sides, the board's determined to dismiss it. This is saying that you're going to notify them, but nobody else is going to know that there was a complaint that was filed. And that loops back and addresses the question that was asked, at what point do individuals outside of the board become aware of a complaint?
Okay.
And the concept would be is if at that point you're finding that just based on those two statements, there's no reasonable cause to believe there's been a violation, the policy perspective is to contain that information to protect the employee who was the subject and to limit the release of the information because there's no basis to believe anything that constitutes a violation has occurred. Now, once you go through that investigation and the complaint has not been dismissed, once you finish the investigation, there are hearing procedures that are laid out. In hearing procedures, this board has a great degree of discretion in determining what a hearing can look like. And what I'm proposing in these rules is merely an option to consider. And it's a procedure that is far less than a civil jury trial or a criminal jury trial as far as due process goes. But hopefully it provides the board with the ability to continue an investigation where the complaint and the response by the respondent, as well as any additional demands for documents that the board has made to county employees or county officers, as well as requests to third parties, has still not fully resolved factual questions the board may have. Does that make sense? So under hearing procedures in K, it says the board may, in their sole discretion, determine that as a continuation of the complaint review process and investigation phase, may direct that an informal hearing be held, conduct the informal hearing, or decide to refer the matter to the appropriate agency of the appropriate agency, take out of, that the respondent is subject to under any state law. Let me try that again now with English that makes sense. Or decide to refer the matter to the appropriate agency that the respondent is subject to under any state law or to a collective bargaining agreement which provides for the conduct of disciplinary hearings. So the board at this point may feel the need to have what will be described as an informal hearing, or the board may take what they've already determined and forward it either to the chain of command if the individual is the subject of a collective bargaining agreement that has specific rules concerning discipline. So let me just speak very, very briefly about that. The county is a party to a number of union agreements, which are referred to as collective bargaining agreements. They're agreements that are entered into between the county and the specific union that covers a whole host of issues regarding employees who are members of that union or associated with that bargaining unit. And also provides specifically for the manner that discipline can be taken against an individual employee. Most often, that discipline comes in the form of what's called a Section 75 proceeding or a Section 75 hearing, which is a statutory code under the civil service law that lays forth a procedure to provide notice and opportunity to be heard for an individual employee when disciplinary action is sought to be taken against that employee. So it may be that this board, if it's looking at an individual who's covered by a collective bargaining agreement, rather than continuing work, may seek to refer its work to the supervisor or the department head so that there can be a consideration of whether this Section 75 proceeding will start, because it would basically require a hearing. So rather than the board do it, there may be a desire to have that go and just work through the Section 75 procedure for a hearing to occur, rather than the board to take further action on that matter if there's a reason to believe there was a violation of the code. If not, and the board is going to proceed with an informal hearing, the board will issue a notice to appear to any complainant, respondent, or other county officer or employee that the board seeks to question based on the belief that such person possesses relevant material information relating to the subject matter of the investigation. The board can request a third party who's not an officer or employee to appear voluntarily to answer questions as well.
But on a mandated purpose, who all are involved in this process of the hearing? Is it just the board with the county attorney's office, or any additional members that are mandated to?
At this point, what the board is doing in an informal hearing would be a quasi-legislative role. So you would be limited, you could limit yourself to the board and the individual who you're questioning. And always the question is whether or not you have your legal advisor present for that or not, and what role the legal advisor plays during that procedure. I do not go into any detail in these rules on that topic, because I think that's something the board should consider on a case-by-case basis with the advice of your legal counsel if it's requested. So that's a very ambiguous response, but what I'm basically saying is this is an informal process where you would be bringing primarily county employees or officers before you to ask questions, and how you go about that practically is something that you would discuss with your legal advisor at that point.
So does the board think we should add a clause here where this is preliminarily just being done by the board and then subjective to where we assess the next step would be?
I don't think anybody else would be present other than your legal counsel and the board members and the individual you're questioning, I guess, if I'm not being clear enough. Yeah, it would be a very, it's not open, it's not a public meeting. You know, respectfully, the county administrator and the clerk of the board would not be present. The only people that would be present would be the board members, the alternates, and the individual questioned, and your counsel if you wanted him or her present.
So if a person being questioned wanted to bring counsel, would that be our decision whether that could happen or not, or do you say, or
Yeah.
would it be the common thought that, sure, that's what you need to do?
The recommendation in these rules is that the board leans over backwards to accommodate that request, and if an employee wants counsel to be present, that the board, as part of the rules, permit that to occur as a matter of policy. And that's one of the areas where you certainly don't have to, but I think it's better. My recommendation for purposes, again, of transparency, due process, opportunity to be heard, allowing that to occur, I think, policy-wise, is a much better position to be in than denying it on
And
a
there would-
case-by-case basis.
Sure. And would there be limitations on that counsel of what they could do?
Absolutely. You know, and we can talk about that and flush that out, whether it looks like something akin to a grand jury proceeding where the attorney is not allowed to speak or address the board, whether the attorney is allowed to make an opening statement or a closing statement, whether there's a time limit put on those things, that's, you know, or whether you just deal with it on a case-by-case basis in your discretion. I don't think there's any, the more detailed you are, the more restricted you are to be flexible in a given circumstance.
Sure.
Because again, I think finding yourselves in a position where you're actually conducting an informal hearing means there's something pretty significant that you've not been able to resolve based on documentation, which I think starts to move you toward more and more towards the provide the due process, provide the opportunity to be heard and those protections in the process. And also to be clear that that collective bargaining agreement language, which may not have been overly clear, now I can maybe even clarify a little better. Arguably, a member of a union would have a right to appear with a union representative at the proceedings, which is why that opt-out is in there of maybe at that point the board would not want to proceed and want to refer it for a Section 75 consideration by the department. Is there any questions on any of that? Because I love this. I can do this all day, and I know you don't want to. I just helping understand the process and procedure is great, and I'm like way over the hour I thought this would take, so I appreciate your patience.
No, there's a lot of directions, a lot of things could go.
Exactly.
I like the idea of the flexibility to say,
To make the decision on a case-by-case. And in here, hopefully you'll see core minimum requirements. So the notice to appear has to be at least 14 days in advance. So the person already knows that the subject, they've already provided a response to the complaint, but you're going to give them 14 days to prepare for whatever that informal hearing is going to be. And that notice is going to have some minimal information in it that's laid out there. More importantly, the recommendation again is because it's informal, the person appearing at the informal hearing shall not be administered an oath or affirmation, and any statements that made would be unsworn. There's no record of the proceedings that would be required unless the board determines in your sole discretion on a particular matter to create a record of the proceeding by recording. again, you're creating flexibility where this is informal, this isn't, we're not creating, and the board's not creating a situation where somebody is going to be held for perjury or anything like that. If that's even legally possible with the board, that's advisory in nature. The goal is to get the questions answered, the person in front of them. And again, those are all recommendations. Were the board to consider a formal hearing, meaning witnesses were sworn, it would certainly look more like a trial in my mind. And I backed off of that process and procedure because I think it would also require the board to then issue something much more similar to a petition or a formal complaint and almost kind of redo a civil litigation lawsuit process of issuing a formal petition, advising of rights to counsel, permitting counsel to represent and argue and appear at all phases. And because, again, at the end of the day, the final result, which will be coming up, believe it or not, soon, which is findings of fact are only advisory, my recommendation for the board to consider over the next month is not going that next step of due process, which is the full ticket, the full meal, the full entourage of bells and whistles, but gearing yourselves more toward getting your questions answered so you can come to findings and then make a recommendation to the individuals who would be the making any final action or taking any final action on the matter. L, dismissal of the complaint after hearing. Again, this is just the provision. Now you've actually gone through and had a hearing. After the hearing, you determine that it's a different standard, more likely than not, that no violation of the code has occurred. Then the board's going to dismiss the complaint with prejudice, meaning at this point, you've run through the full gamut of your procedures. And after doing all of that, more likely than not is a higher level than reasonable cause. More likely than not, we often say is like 51%. So if you have to say yes or no, and you have to pick one, which is it? Yes or no? And if the answer is no, there's no violation, at that point, you've done the full process. You would be dismissing the complaint with prejudice, which means you're not going to rehear it. It's gone forever. It's off the table. And at that point, because there's now been some informal hearings and document production, you're also going to make sure you notify the chair of the Board of Supervisors, the county administrator, the director of human resources, the department head for the county officer or employee, any hearing witness that appeared, the complainant and the respondent in writing that the board dismissed the complaint and that no further action will be taken concerning the matter. So at that point, you're notifying a lot more people because a lot more people now know that this has happened and occurred. Is there any comments on that? Or county administrator, especially, I'd love any input you have on that.
I thought it was well crafted.
Especially on notification to people. I wanted to make sure we covered at least the core. It doesn't mean there may not be more. Really, at that point, it's the board's obligation, I think, to minimize any harm to the employee based on the finding that there wasn't a violation. And then if there is going to be a finding by a majority vote that it's more likely than not that the code was violated, then you're going to prepare advisory findings of fact and law. It would be signed, the final report would be signed by each board member who votes to approve the findings. That would then go to the county administrator and the department head for the county employee for further disciplinary review and appropriate action. It would also, if it's a violation involving the department head or a department head, any county elected official or the county administrator. Then the members of the Board of Supervisors, the clerk of the board, the county attorney, and the director of human resources all get notified. So the questions on that breakout, we've had that, the county administrator and I have had to kind of work through that on some other policy recently. And the goal there is just to make sure that nobody falls through the cracks. So whoever it is in the county where there's an report that goes through to investigation or findings, report of findings. Let me back up for a second, because I think I may have misspoken, although I think the rules are clearer. So if the board stops without doing a hearing, and based on the documentation, you determine that there's a violation, that's what this is here. So it can be the findings of fact isn't just for when you have a hearing. It's when you get to the point that it's more likely than not that a violation has occurred. That's when that report of findings kicks in.
Is there any provision of informing the board of supervisors if there was nothing credible found at that point, or is it just only when something is credible and actionable?
Let me back up. So I believe the question would be answered under L, except L is L is dismissal of complaint after hearing. And I'm going to say after investigation rather than after hearing, because hearing is a continuation of the investigation. So I think that's a little deceptive. It's possible that you don't have a hearing.
Right. Hearing seems like a much more advanced phase.
Yeah.
So, yes.
Yeah. So I'm going to make that L say dismissal of complaint after investigation, and that may or may not include a hearing.
Okay.
That's up to the board. But at that point, many more people get notified.
By changing it to investigation, does that subdivision J, the paragraph J deals with dismissal of complaint after issuing notice of complaint and investigation.
Yeah,
So by changing from hearing to investigation, do those two now step on each other's toes?
which is why I guess I did hearing, right? And I
So,
think
there's previous sections dealing with earlier dismissals. This section is dealing specifically dismissal after hearing.
Yep, I think we should leave it. And let me back up now, and I'll tell you my thought process. My thought process, I believe, was after hearing, there's just many more people who know about what's going on. And because now there's even more people, and after the document investigation, it's a longer list of people who get notified.
Right. So as you previously described the tiered system, this is after that tier, the dismissal after the highest tier of hearing.
Correct. Now that tier does not say all of the Board of Supervisors. It just says the chair of the board, the county administrator, human resources, department head of the employee. Because my gentle recommendation is it's a dismissal. And I think it should be for the county administrator and the chair of the Board of Supervisors to determine how much farther that dismissal goes as far as notification. I think now if we go back to M under the findings of fact, under sub 3, maybe that's not large enough. That says the board shall refer the report of findings for the matter to the county administrator and department head for the county officer or employee for further disciplinary review and appropriate action. Now, my thought process there was the board has determined that there's more than 50% probability that an individual violated the code. And my thought process, I believe, was to let the appropriate individuals see your findings so that they can then make the determination of what they're going to do for discipline. And I think the reason that should not go, my recommendation is the reason that should not be widely disseminated is because there's a process and procedure in place for the department head and the county administrator to then follow in determining what, if any, actions to take for discipline on the individual. And that's, again, assuming that it's an employee or officer who's not a department head, who's not elected, and who's not on the board of supervisors, you know, the rest of that list. Because that then becomes an employment matter. And because it's an employment matter, it is sensitive in nature, and you're making it a recommendation only. And I think that recommendation should be protected and not widely disseminated so that the employees' due process rights and the discipline process are not violated. Please feel free to, again, questions, comments, disagreements.
I have a question about record keeping in general. What is it clear enough in here what happens to the complaints that are dismissed? Do we keep them? Are they shredded?
They are records. They will be kept. I don't believe there's any right or authority to destroy them as records under public officer law. There's a second, so I think that answers the question. I don't want to answer the next question you may have, but I think as far as records, I'm going to add a provision to the standing rules that the board on an either annually or biannually designates the county attorney's office as the department that will be the repository of board records, and that will keep them in compliance with other laws. That would be probably a very, just to really, really be super clear. I think it's kind of the intent of the code, but it doesn't specifically say that. So let's add that in there. And that might be something to recommend directly in the code as well. But certainly for this year, at the next board meeting, I'll have a proposed resolution that'll accomplish that task for the board to consider. I appreciate you mentioning that.
And if the complaint was not an actual complaint because it wasn't filled out correctly, do we have to keep that?
I think the answer is yes, if it's mailed and or personally delivered.
Email? I mean, if it's not the correct.
Well, I don't think emails are, I think the policy is pretty clear that email or text or a fax isn't anything to us, and we're not going to take action on that at all.
Well, that's what I'm saying. If it's not even a legitimate complaint because of the format,
Yeah.
do we just get rid of those?
I think when a document comes in either through delivery or mail, and it's then forwarded to the chair to determine if it's facially compliant, I think we're obligated at that point to keep it, even if it's rejected, right? We send a letter that says, you know, the complaint's not being acted on because it doesn't comply with the rules. We attach the rules. It has the sample form in there. We still have, I think we should certainly still keep that, and we will. At that point, it doesn't have a complaint number attached to it because it's not officially a complaint. But I think if my office is designated, I'm not comfortable saying that that document should be shredded or thrown in the waste pail.
Yeah, I just wanted it to be clear in the rules
Okay.
related to
So let's stop here and back up a little bit. On the findings, it says that each individual who supports or votes for the findings, report of findings, is going to sign it. which brings back the question of who's signing these documents, right? So there's a number of different documents referred to throughout the policy. Maybe it's the notice of complaint. I don't see that the county attorney or the county attorney's office should sign those documents. Those appear to me to be official documents from the board. So the question is, when there's a majority vote to take action and to take the next step, who's going to sign that document? Off the top of my head, I think the individuals who voted for it should have their signature on it when it's issued. It could also be the chair alone. So I don't want to make a big issue out of maybe what is a small point, but I think it sends different messages between having the chairman sign what's been approved versus having the individual members sign. Additionally, it does create a little more difficulty and time to actually sign the document than for each member who at each step approves the issuing of the document, right? So I think clearly for the findings of fact, it should certainly be signed. My recommendation is everybody who votes for it should sign it. The question is those other things that we've already talked about, who signs it? So the notice of failure to file or a financial disclosure statement. Should the chairman or chairperson sign it? That seems, I mean, that would be my recommendation. That would be pretty simple. As we start to move into this, the notice of complaint, I think that might be, that's your call. If nobody has an opinion today, I can just kind of do it with a blank for next month and you guys can get back to me next month.
I obviously don't want to burden the chairperson, but obviously I think that it should be coming from the chair. I think that makes sense that it should be coming from the chairperson. I don't know. I mean, obviously a lot of these are going to be form letters, I think, as you talked about. So I don't know if it's possible to have, just the form letters with the chairperson's signature on it or whatever.
I think practically we can work through that.
Yeah.
That on a
I mean,
chairperson by
in
chairperson.
terms of the number of, actual individualized letters that are going to be sent that aren't the form letters, I think will be infrequent enough that the chairman of the signature of the chairperson should not be too burdensome.
Okay. So that's how I'll put it together. And again, it's just a reference to FOIL that a complaint might be foilable. Doesn't mean that it would be, just that it's a possibility. And then, we're almost there, advisory opinion on enforcement. So the board, in addition to that findings of fact, may also at that same time provide an opinion on enforcement for the violation. It does not have to. But if you are going to issue a recommendation on enforcement, it has to be included with the findings of fact. Not something that would be done at a later time. And then, of course, for lack of a better word, the disclaimer is the use and effect of any findings of fact and/or advisory opinion on enforcement shall be made solely by the county officers or employees, supervisory chain of command, and not by the board. So just reinforcing that it's advisory only.
I think it's pretty thorough in general.
I thank you guys for bearing with me while I talk way too much through those. It was a lot of ground on a lot of topics. If you have any individual questions that you think of after the meeting, feel free to contact me on that or concerns. But I will take what we've discussed today, turn it into a proposed final version. And I will get it out to you well more than 3 days before the meeting. So you have plenty of time to review it in detail. Anything else on that before we conclude new business?
Any other comment or feedback? good with this, Eric?
Excellent. So if the board wants to move on to talk about announcements,
Right, and if there's any public comment, which we don't have any public, so.
yeah, I don't think there's any on YouTube. I don't think anybody's logged in.
Mr. Moore, would you like to address us in any ways?
No, sir. No, I think these are very well done, and the tweaks made today would make them even better.
Thank you. All right, that brings us to the announcements for the next scheduled meeting date and time. Wasn't sure if this was easier for us to pick some options now or do it just like we did the last time. I'll completely defer to everyone on the board.
I would recommend that we defer until our next proceeding, which is not subject to the open meetings law. Because as we go through the items that are on the agenda
May have to pick another date.
for the next proceeding, it might become clear or more or less clear that we need a sooner or a later date. How's that for being completely ambiguous and non-committal?
No, that works. All right, so we'll defer that for executive session and then we can announce that as we come out of that.
So if we wanted to move forward with a motion to adjourn, we could do that at this time.
Yeah, I'll make the motion to adjourn
I'll second it.
and all in favor.
Aye.
Aye. We are coming out of the public meeting at this point.